Good afternoon, everyone, and welcome to our webinar on how can I protect my brand, trademark tips and tricks for business. Thank you for joining us. My name is Amanda Curry from New South Wales Business Chamber, and I will be your moderator for today. I am joined today by Louise Babin and Susie Leask. Hello, Louise and Susie.
Hi, Amanda. Hi, Amanda.
Welcome to today's webinar. Today's webinar will cover how to protect your brand, especially in the evolving digital space, branding tips and tricks to ensure your products and services are distinctive, and what are the benefits of a registered trademark, how to successfully achieve registration of your trademarks, what to do if your trademark is infringed by another party. Very interesting. If you have any questions today, please submit these via the chat box on the bottom left of your screen. Both Louise and Susie will try to answer as many questions as they can throughout the session, noting that some of the questions you may have early in the presentation will be covered throughout the session. I will now hand over to you, Susie. Welcome.
Thanks, Amanda, and thanks everyone for joining us today. We thought we'd dive right in and start with talking about why brand protection is so important in business. Whether you're a startup or if you've been in business for a while, it's very likely that one of your most valuable assets is your brand, or in legal terms, your intellectual property or IP. One of the first things business owners often do is get business insurance, but what about protecting your ideas, inventions, brand, business name, or logo? These are all things that you spend a lot of time and money building, marketing, and promoting. So they're certainly worth protecting and also making sure you actually have the exclusive rights and ownership of your business's IP. Protecting your IP can help distinguish you from your competitors and ultimately increase the value of your business and its goodwill, which is really important if you wish to sell or approach investors in the future. It can also deter others who search the IP Australia trademark register from adopting your business's brand names or a similar logo. A registered trademark is essential to protect your brand and ensure that you have exclusive and enforceable rights over these valuable assets. We know trademarks is something that businesses often overlook. You might think it's too costly or that your registered business name and domain name are enough. And spoiler alert, right up front, it's not enough. Failure to monitor and properly protect your IP through a registered trademark can put your business at risk, particularly if a competitor beats you to registration and your brand is lost to that competitor. So today we're going to show you how to protect your brand, and we're going to broadly cover these four main topics. First up, some intellectual property basics and an explanation of trademarks in particular. We're going to talk about some expert tips and tricks to ensure that your brand is distinctive, and we'll explain the process of registering a trademark and some common traps to avoid. Finally, we'll talk about the benefits and also the risks of not having a registered trademark, plus some strategies for protection of your IP and what to do if a competitor is using your brand or infringing your IP. So let's dive right in. And Louise, I think it's really important to start with these little symbols, which are widely recognised, but not always properly used or understood.
Yes, that's actually very true, Suze. People often get these confused. So this little TM symbol can be used alongside a trademark irrespective of whether it's registered or unregistered. The TM symbol indicates to others that the trademark is used as a trademark by the owner or authorised users in respect of the goods or services to which it is applied. Often owners will use this symbol once their trademark has been applied for, but has not yet achieved registration. Either way, it is merely an indication that the mark is being used as a trademark. And then, Susie, the little R symbol, on the other hand, indicates that the trademark is a registered trademark. You should only ever use the R next to a trademark that is formally registered in the country in which the trademark is in use.
And the reason why this is such an important distinction is because it's actually an offence to falsely represent that a trademark is registered when it isn't. So you really do need to use caution before putting little R's everywhere on your marketing material, at least until your trademark is actually registered. So let's go back to basics for a minute. This table is a really useful reference for the most common types of IP and other interests. All businesses should identify what different types of IP you might have and how to protect it. Most businesses will have more than one type, and you should factor that into your overall IP protection strategy. For some businesses, patents will be really crucial. This protects inventions and new processes, and it's a right that's granted for any device, substance, method or process that is new, inventive and useful. So for example, a cancer drug or Apple's patented smartphone features, which it famously sued Samsung over. Copyright, on the other hand, protects the original expression of ideas, for example, books or software. A design refers to the features of shape, configuration, pattern or ornamentation which give a product a unique appearance, and it must be new and distinctive in order to be a registered design. Confidential information or trade secrets may also be a valuable asset of your business. This is commonly protected by a contract in the case of employees, or a confidentiality agreement with your investors or service providers to stop them stealing your ideas and valuable confidential information. For the purpose of today's presentation, we're going to focus on trademarks. Typically, a trademark is a word, logo, slogan, or catchphrase. A registered trademark is what provides the exclusive legal right to use, license, and sell the mark in Australia. Now, the key word there is exclusive. So if you're taking notes, this is the bit that you want to write down, the spoiler alert that I was talking about earlier. Company names, business names, and domain names do not give you an exclusive right to use that name. Only a registered trademark will give you the exclusive legal rights to your brand and allow you to protect that brand and prevent others from imitating or using your brand without permission.
So let's take a look. What's the difference? Well, starting with a business name. This is the name under which a business operates. Registration is compulsory with ASIC, and it can let others know that you exist and to choose another name when they search the ASIC business name register. But a business name does not provide intellectual property rights in the registered name. Company names. Well, most businesses would have a company name, which you may have chosen when your accountant or your lawyer incorporated your company with ASIC. If a company wishes to trade using a name other than its registered company name, it must also register that trading name as a business name. So, what is a domain name? It's the unique name that corresponds with an IP address or web URL. You must provide an ABN to register any .au domain. Now, this is important. The owner of a trademark that is identical or deceptively similar to a domain name can file a complaint and seek to have the domain name transferred to them. Now, our important topic, what is a trademark? A trademark is a sign, often called a badge of origin, used in trade to distinguish goods or services of one business from another. A trademark can appear in many forms and is what gives you the exclusive legal right to use a name, image, logo, slogan, etc.
So the reason it's really important to understand these four particular concepts together is because if you go to register a new business, company or domain name, or indeed a trademark, and it's identical to or similar to another party's registered trademark, you could be sued for trademark infringement, passing off, or a breach of the Competition and Consumer Act for misleading and deceptive conduct. Now I can see we've got a question that's popped up here from the audience, and they've asked, which type of name is most important and what do you recommend that I register?
Oh, I might grab this one, Suze. So they're all important because they all have different purposes. So, in short, business names, company names, domain names are best protected when they are also registered as trademarks. So, as you said, a trademark is what gives you the exclusive intellectual property rights in that name. As for what to register the name of the business, the company name, the domain name, if any of these are different from one another. A social media hashtag branding, that's very important, especially nowadays. So anything recognised as distinctive of your business in the marketplace. So individual products, individual services, catchphrases, they can really stand you out from the crowd. So basically the message, I think, to answer the question is to look for maximum protection.
Great answer, Louise, and thank you for the question. Keep sending them through. Just having some trouble moving to that next slide. Oh, there we go. So jumping into some trademark basics and tips and tricks for success. Starting with the basics, you can see that there are a lot of different types of marks that can be trademarked, from words, logos, pictures, to slogans or catchphrases, and even Twitter handles and aspects of packaging, or a combination of these. Qantas is a really good example of a well-protected, multifaceted brand. They've trademarked the word Qantas and also their logo, the famous kangaroo that we've all seen on the side of their planes, as well as the catchphrase, the Spirit of Australia, plus the brand of their other products or services such as Jetstar and so on.
So there are some obvious forms of branding which are important for businesses to protect. For example, a business or trading name. These are often represented in the form of words or logos, and we can all see the power of, say, the Nike tick or the Apple symbol. However, businesses should consider all the branding that they use, not just the name of the business. Businesses should consider protecting slogans, catchphrases, and Twitter handles. So think of the success of some now household names which have exploited their branding. For example, Nike, Just Do It. Subway, Eat Fresh. Toyota, Oh What a Feeling. We all know these popular catchphrases. They are all instantly recognisable. Indeed, as you mentioned earlier, Susie, Qantas have also trademarked catchphrases all day, every day, low fares, sharing the spirit, create your dream holiday experience, Qantas frequent flyer, even the term sky bed.
And they really do have a lot. Excuse me. And you might even take it a step further, like some iconic brands do. We all know the Tiffany blue box, which is a registered shape and colour trademark. Veuve Clicquot has trademarked the specific colour orange used on its champagne products. So as you can see, there are some simple branding techniques and the right protections, which together can provide you enormous business opportunities. So what are some of the do's and don'ts for selection of trademarks? If your mark is merely descriptive, it may be rejected by IP Australia. So a good tip is to couple a descriptive mark with a slogan or catchphrase. This enhances its distinctiveness. And you can also do that by combining it with the use of a logo, which is a handier way around the descriptive issue.
That's a really good tip, Susie. For example, we have a client called Performance Drivers. It offers a service which provides professional expertise by senior people. They are promoted with the catchphrase, grey-haired gurus. Performance Drivers has successfully trademarked this branding. Indeed, one of the reasons this slogan mark was applied for was that they had trouble registering the word mark as it was rejected by IP Australia. So they registered their logo and their slogan. This has provided them with effective protection. Word marks are sometimes more difficult to register. So these approaches are useful, especially if you've been using a mark for a long time but haven't yet registered it. It saves you rebranding.
It's interesting, isn't it, that a word mark is actually considered to be stronger than a logo mark as it covers the words in the mark. However, as you've said, word marks are more difficult to achieve successful registration. So in some instances, a logo mark is an easier road to success. And these are easier because the mark is judged as a whole and the impression it makes in the minds of the relevant public. Often logo marks are more instantly recognisable in the marketplace when you think about Facebook, Twitter, Apple, VW, and the McDonald's Golden Arches.
So when we think about slogans or catchphrases, they can certainly turn your small idea into a big hit. Think of your individual products or your individual services and consider trademarking those. You don't want a competitor to beat you to it. So marks that sound similar, so even if you come up with a cool spelling of a word, if it sounds the same as another mark, it will be rejected if it is likely to cause confusion in the marketplace. So bear that in mind. Importantly, don't mislead. So if you're not Donald Trump, then don't try to register a mark like Donald Trump's Advice Centre. Your mark will be rejected. And no geographical references. IP Australia will reject a mark if it has a geographical reference, even a reference to a place which is not in Australia. In fact, I once had a client who wished to register its business branding for a sushi train business. It made a reference to a tiny town in a remote place in Japan. The examiner rejected the mark. I thought this was harsh, but unfortunately, rebranding was necessary as they hadn't sought advice until they were advised of the rejection. So do your homework. My best advice is to seek advice, particularly around the selection of the appropriate classes of goods and services. There are 45 to choose from, and it's essential to make sure the brand is protected in all relevant areas or classes of products and services. Actually, we'll address this further later on in our presentation.
So we've actually got a couple of questions coming through. Thank you for sending them. Kristen, you've got a couple of questions there, and I think the first one we may deal with later in our presentation in relation to infringement, or where there's someone who has a very similar name. So see how we go, and we might answer that one as we go through. But your second question is, so should brands do 3 trademarks, one for each area, so a word mark, a logo mark, and a catchphrase like Qantas does?
Kristen, I think that's ideal. You should cover the bases, do all 3. So a lot of clients will do their word, their logo, and their catchphrases, all 3. And indeed, I have clients who not only do that, but they also have particular product names or service things that maybe they've got a catchy slogan or something for, and they will do those as well. Just cover your bases, protect what it is that will make you distinctive from others.
I think that's absolutely right. And what we're going for here is maximum protection. And as we said, the word mark is, of course, the stronger mark, and it can stop other people who have a very similar words included in their name. So you might be able to object on those grounds. And then similarly with your logo, that stops other people using a logo that's similar to yours, and same with the phrase. You know, if someone comes up with a similar catchphrase, if you've already trademarked that, then you've got that protection, and we'll talk about how that infringement process works in a little bit later on in our presentation. So let's have a look at some examples of tricks to assist you with making a descriptive mark, more distinctive. So these sound pretty basic, but the key is finding a solution to get your brand registered and protected. We can't all be Apple, but you don't have to be fancy, you just have to be smart.
That's exactly right, Susie. You can improve a pretty basic mark by including your catchphrase. So Mike's Barbershop or Sue's Taxation Services, which may have trouble, they can become Mike's Barbershop, a good cut's a quick cut, or Sue's Taxation Services, a good cut's a tax cut. So turn it into a logo. This makes it even more distinctive. You should use your full creative arsenal to stand your mark out from the crowd.
They're really good tips, Louise. Thank you. So in this digital and social media age, businesses should really also be considering applying to trademark their social media branding, whether it be your brand on Twitter, Instagram, Facebook, or other platforms. And I understand, Louise, you are actually the first practitioner in Australia to successfully achieve a hashtag style trademark for a client, which is pretty cool.
Yes, it's actually true, Susie. This one was initially rejected by IP Australia as they weren't keen on the whole hashtag trademark initially. So I presented an argument to IP Australia. We had to do a bit of work, but ultimately this was accepted by IP Australia. Successful registration was achieved, and of course the client was thrilled. So it's very important for businesses to consider applying to trademark in social media branding. A registered trademark is a very powerful tool in the context of emerging technologies. Indeed, it's not unusual for source data or search engine optimization or keyword strategies to contain brand references. With new technologies at our fingertips, our ability to exploit branding has exploded. Utilization of brand names on Facebook, Instagram, and Twitter is commonplace. Whilst this practice can enhance the awareness and profile of a business, it can also pose a potential risk when it was used to the detriment of a brand. In fact, I recently wrote an article regarding the use and protection of branding within meta tag data, so it's worth visiting the Australian Business Lawyers and Advisors website if you wish to find out more.
I don't think we can state strongly enough today the importance of protection through registered trademarks. The strong protection that you get for a relatively small outlay is certainly well worth it. And the reason for this is because it gives you a relatively easy and cost-efficient legal action against infringers using the same name or the similar trademark in relation to goods and services, which are the same or similar to your goods and services over which your mark is registered. It's also a complete defence to any claim of trademark infringement brought by another trademark owner. And in addition to the monetary value of a registered trademark, in that you can sell or license it to others, it's also on the public record. So third parties who search the register are more likely to choose a different mark for their business. So it can be a really effective deterrent against competitors and copycats. Often a comprehensive IP protection strategy covering your different types of IP is necessary to maximise protection and the potential commercial value to a business. So in short, if a business does nothing else, it should at the very least register the trademarks over the brands that it uses.
So preparing for registration. Before you start the process, identify the trademarks you're using. Think creatively, because really a business with a soul becomes relatable to its target audience. Assess the value of the marks to your business. Decide which trademarks to protect. Remember, you're courting a target market across a broad range of utilities. Search the trademarks register. You may find that your proposed marks will infringe upon the rights of a mark which is already registered. Act. Do something about protecting your trademarks now. Trademark rights arise immediately they're registered. And importantly, be the first. Don't wait for your competitors to beat you to that.
That's some really good advice. And I think it's really important to emphasize here that your searches or your due diligence is possibly the most important step, and it needs to be done carefully, and thorough research should be conducted. It's not enough just to look at the IP Australia trademark register. You have to really do your homework to make sure no one else has already obtained rights to your proposed trademark, or that they're using a similar mark in the marketplace. If you get this wrong and miss a competitor, your use of their trademark could expose you to liability for trademark infringement or other breaches of the Australian consumer law. Now, Louise, you've done thousands of these searches, and I have to say you're the queen of finding and flagging for clients potential conflicts wherever they might be located in the depths of the internet. What tips do you have for conducting searches before you go ahead and register a mark?
Well, what's important is to analyse the results of the searches. It's often difficult to know, Susie, whether or not a conflict with another brand exists. The brand may exist, but how do you know it's protected? Businesses should focus their attention on important potential conflicts to ensure appropriate branding selection, to provide an easier road to successful registration. Often clients spend a great deal of money on designers who'll provide them with catchy branding and famous and fabulous logos. Time and effort goes into marketing plans and product and service launches. Then, if no searching has been conducted, their application may be met with a requisition from IP Australia or a third party by way of a formal objection to registration.
So the message there is do your homework and be thorough. I think this list on the slide gives you a starting point, but as you say, the analysis of results in the context of the Trademarks Act and IP Australia is really the key, as well as thinking outside the square, such as similar sounding or other variations on your proposed trademark which might be similar. It's certainly worth considering seeking expert legal advice in the selection of your potential trademarks before you spend time and money on expensive marketing and branding. So as we mentioned earlier, once you've decided upon the branding that you wish to protect, the next step is to determine which goods and services claims you wish to connect to your marks. And this is the complex part. As Louise mentioned, there's 45 classes of goods and services, and you have to select the correct claims which reflect your core business activities, or select an accurate reflection of your individual goods or services. You then have to ensure that the claims are placed in the correct class.
So this is where expert help sometimes is necessary. I'll give you a quick rundown. Claims, they're the descriptions of goods and services which are appropriate for your mark. Say, for example, you're registering a trademark for your shoe repair business. You might be tempted to select goods in Class 3, which broadly covers cleaning preparations, and perhaps select polishes for shiny leather, or leather waxes, or creams for leather. However, unless your business is actually producing the polishes, waxes, or creams, then this would be the wrong selection for a shoe repair business. Rather, you should select the services of shoe repairs, such as those in Class 37, which broadly covers repairs, and select repair of shoes, footwear repair services, leather care, cleaning and repair. These services will accurately reflect the core business activities of a shoe repair business. This example might be straightforward, but this is an area which can be pretty tricky. If you do not make appropriate selections, then you run the risk that your mark will be removed from the trademark register for non-use. Correct selection is vital if you wish to ensure that your mark is protected in the way you envisage. We have clients who contact us with news of a potential infringer. Sometimes it's discovered that the client cannot enforce their rights because correct class claims were not made in their application. Put simply, their mark did not protect the correct goods or services and this result can be extremely disheartening. Once an application is submitted, only on rare occasions can amendments be made. So select correctly or potentially suffer the awful consequences.
Okay, so on to the next section now, moving on to what I know many of you will be keen to know. How do you actually register a trademark? So this is the flowchart provided by IP Australia, and in short, it's pretty complicated. Louise is going to break this down for you in a little bit more detail, but the basic steps are, of course, your application, examination by IP Australia, responses from IP Australia and overcoming any issues raised, and then if you're successful, you move on to acceptance and advertisement to see if any oppositions are raised by third parties, and finally, the magic registration.
So once your application is submitted, it will be examined by an IP Australia examiner. This examination process takes approximately 13 weeks. The mark will either be accepted or an examination report may issue from IP Australia, which raises many issues, such as potentially similar marks or reasons why you can't register that particular mark. So common reasons are that the trademark is too descriptive and not distinctive enough to be able to distinguish your services and goods from other traders, or it is too similar to an already registered trademark and IP Australia think it is substantially identical or deceptively similar to your proposed trademark. An examination report is effectively an obstacle to registration. An initial refusal, though, does not necessarily mean the trademark will not eventually be accepted for registration. However, these objections can be difficult to overcome and require proper evidence in support of your application and a valid explanation and legally based reasons as to why it should be registered.
Okay, so we've got a few questions coming through here, and a couple of them we'll leave to a bit later because I think we'll cover them in a later section. But the first one we will answer is, can I respond myself to the examination report, or do I need a lawyer to do it? And secondly, what happens if I do it myself and my first response fails?
Okay, Susie, so you can do a response yourself, but most clients will require the assistance of a trademarks lawyer at this point. Responses are often only admissible by way of a statutory declaration, and they provide substantial amounts of evidence. It can be quite a lot of work putting that evidence together, especially in a form acceptable to IP Australia and in a form that supports your argument for registration. So very occasionally, a client will attempt to respond to these objections themselves, and then they find that the evidence is insufficient or unacceptable, or perhaps their reasons don't adequately address the available legal arguments. Unfortunately, if you choose to respond yourself and that response is not accepted by IP Australia, as it may be considered inadequate, you may run out of time to provide another response which meets the evidentiary requirements of IP Australia. So I would caution against doing it yourself unless it is very obvious mistake or perhaps even a minor issue. Generally, this is where you want a trademarks lawyer, one who has experience with answering objections and knows the types of responses that will be successful and has knowledge of a practical solution to get you through the process through to registration. So our next steps. If no examination report issues or any objection is overcome, then the mark will be accepted by IP Australia and will proceed to publication in the Australian Official Journal of Trademarks. This then provides interested third parties with a 2-month opportunity to object to the registration of your mark. If an objection is received, it must have appropriate grounds upon which to object. A hearing may ultimately result, although this is very rare. Restrictions may be placed upon the mark in relation to geography or limitations on goods and or services in order to get the mark over the line. If no objection is received by IP Australia, then the mark will progress to registration. You are then at liberty to display that little R symbol we spoke about earlier when displaying your marks.
Louise, you mentioned a really interesting point, which I think we might expand on a little bit, as I know you've had to do this many times before. Often an objection, whether raised by IP Australia in the examination report or by way of opposition during the publication stage is raised because a similar mark's goods or services claims overlap with someone else's mark. However, it might be very obvious that they're not doing business in relation to similar goods or services to you. So what we often find is that you can come to a commercial arrangement to get the mark over the line, as you put it, where you say, okay, I'll amend my application so it doesn't cover their particular goods or services class, and then the owner might consent to let your registration pass. So, for example, a restaurant name or logo wouldn't need to be registered in the same class of goods or services as an IT or software development company.
That's actually right, Susie. In fact, last week, a client who has marks in the medical industry was approached by the applicant of another mark. The marks have similarities, but my client does not feel that the mark will cause confusion in the marketplace, as the applicant operates in Queensland is only in relation to hearing issues. So just as an aside, medical and hearing services claims overlap in class 44. The examiner at IP Australia has indicated that if my client consents to the registration, it will likely proceed. Just to be certain that my client's mark will not be impacted by the registration of the mark, I'm currently negotiating with the applicant of the other mark so that a limitation can be placed on the other mark, indicating that registration of the trademark is limited to the state of Queensland. Such a limitation is acceptable for IP Australia. In addition, I'm requesting that the applicant does not make another application in the future for a mark outside the designated services claims already indicated.
So the moral of the story there, I guess, is that there is more than one way to achieve registration.
Yes, Susie. In fact, most applications don't encounter difficulties and run smoothly to registration.
Okay, so once we get that magic registration point, what do you get? So trademarks are initially registered for 10 years, commencing on the filing date of the application, so not the registration date. And then you can renew for further periods of 10 years. The cost of registration will vary depending on how many classes of goods or services you choose to cover. And currently, IP Australia fees are $250 to $330 per class. So that's why people generally don't register across all 45 classes, plus you likely have some class registrations removed for non-use. If you have an Australian trademark, you can then apply for a World Intellectual Property Organisation or WIPO Madrid Protocol registration of your mark in other countries through IP Australia. And with the expanding global economy, social media and digital marketplace, online branding registrations in the US, UK, Europe and China in particular are becoming increasingly popular. It can also be something to think about early on if you think you might expand to export goods in other jurisdictions, or if you have overseas customers via your online platforms. However, you do have to be careful that you don't just sit back for 10 years and not do anything with that brand. The saying, use it or lose it, applies here, as you can lose your trademark registration in certain circumstances. For example, for non-use, if it hasn't been used for 3 years, or if you fail to pay the renewal fee.
Quite right, Susie. There's a recent example to this in relation to the furniture giant IKEA in Indonesia. IKEA registered its mark in 2010 by basing its application on the Australian mark, a WIPO registration, and then an Indonesian entity registered IKEA in lowercase type in 2013. However, because IKEA did not set up their first store in Indonesia until 2014, the Indonesian entity alleged that IKEA had not been using the trademark. Ultimately, the IKEA mark could be removed in Indonesia for non-use. Importantly, in addition to this issue, it turns out that the application for the IKEA mark had included goods and services which were far too broad, and IKEA had not used the mark in relation to the broad goods and services claims made. As you say, Susie, this highlights the importance of use it or lose it and the significance of carefully choosing goods and services claims.
That's right, and we've got another question here from Kristen, which is how does the trademark registration renewal process work? Will they contact us or do we have to do something first?
Well, if you are the address for service for the mark, then IP Australia will contact you after the 10-year period, the first 10-year period has expired, and it gives you the option to renew or to allow their mark to lapse. At that time, you have a window of opportunity and you can simply pay the fee straight to IP Australia on their website and it's done.
So I guess that's really important to keep your address for service updated if you do move premises, or you might want that address to service to be your lawyer or your accountant or someone who is always in contact with you and can pass that on and knows your current address.
Yes, we have quite a few that do that.
Yeah, that's right. So moving on to infringement and protection strategies. What happens if you don't register your trademark, or maybe you've just tried to register it and you found a competitor has beaten you to it? Even if you were the first in the market, a business will be left with Even if you were the first in the market, a business will be left with common law protections, which can be expensive and difficult to prove. We've touched on them a little bit already, but they include an action for passing off at common law, where you'd argue that the other party was trying to pass itself off as your brand or business. Or you've got potentially an action for misleading or deceptive conduct under the Australian consumer law. And this, of course, depends on your particular circumstances and the competitor involved. So it really depends on the facts. But by far the most cost-effective method of protecting branding is by registering a trademark. Without that trademark registration, you're really vulnerable to misuse by third parties and you have limited available recourse. If you do have a registered trademark, then you'll have available a three-pronged approach to an infringer. So first, a passing off action, misleading or deceptive conduct, and an action for trademark infringement under the Trademarks Act.
So, and the protections provided under the Trademarks Act are a more direct approach, as your rights immediately arise once the mark is registered. The Act also provides particular grounds upon which you can enforce the protections afforded to the holder of a registered trademark. So let's talk about infringement of your IP rights. What can you do if someone infringes your rights? Get expert help. Talk to a qualified IP lawyer about your options. Send a letter of demand perhaps, or a cease and desist letter to the offender. Consider potential legal proceedings for breach of relevant laws, for example the Trademarks Act. To be successful in an infringement action under the Trademarks Act, it's necessary to show that the infringer of the mark was used as a trademark, the infringing trademark is identical, substantially identical, or deceptively similar to your registered trademark, and we have to be talking about similar goods or services or both in relation to which the infringing trademark was used. There are defences. There are a number, in fact, including that the infringing mark has been in use since a date prior to the date on which your application was filed. Additionally, as Susie mentioned, you may have common law action for passing off or breach of the Competition and Consumer Act. These claims are usually harder to establish as they require proof that your mark has developed a reputation in the market, something which is not necessarily to prove in an infringement claim.
Okay, so before we talk protection strategies, don't forget to think offensively as well as defensively. Keep an eye out for potential commercialisation opportunities. Registered trademark owners can gain additional income from licence fees, and this is usually by way of a licence agreement, which enables a third party to use the mark as agreed by the business. For example, exclusive use by a distributor in a particular region, and this can be a really good source of passive income. Also remember, we mentioned earlier that trademarks are a valuable asset of any business, especially in relation to the goodwill created by them. This makes them a sellable asset which can be sold on its own. For example, if you wish to sell a product line or business unit, or you can sell it as part of the assets of the business in a business sale, which can really boost the sale price if your brand is recognisable and it has valuable goodwill in the market with your customers. So there's another question that we've had just earlier about non-use, and it's from Kristen. What do you mean trademarks can be removed for non-use? What constitutes non-use?
So non-use is literally not using your mark. And it's not just for, banners and flyers and letterheads and things, which are all important. But even if you're not using those, if you've got an online business, your use online is use as a trademark. Anything that you are using your mark or logo or catchphrase for, which is you are trading under that banner in some way. So if you're not doing any of those things, it can be non-use. But generally people, if you're trading under it, you're using it.
Great, thank you, Louise. So moving on to an IP protection strategy, what we recommend is first up, you need to identify the types of IP used in your business. And there might be multiple types. You might have patentable technology or inventions, copyright in written works, brand names you wish to trademark, and confidential information or trade secrets. You need to assess the value of that IP to your business. For some businesses, your brand may be crucial, and for others, it may be worth spending money on a registered patent instead. Decide what IP you'll protect and how you'll protect it. If you've got confidential information or trade secrets, then you want to make sure that you're using a confidentiality agreement in your negotiations or your meetings with third parties. So if your business is online, obviously you're going to have to register your domain names across as many domains as you can, .org, .com.au, .net, and so on. Make sure you do something about protecting your IP, whether that's doing some market research, talking to a commercial lawyer, conducting searches of IP registers and ASIC registers to ascertain availability, putting confidentiality agreements in place, filing registrations over your IP where applicable. And finally, be the first. Don't wait for your competitors to beat you to it. Now, I think we've got another question here that's come through from Jessica. And the question is, what happens in the renewal process if you want to make amendments to the logo or classes?
So Jessica, the answer to that is very simple. When you register your mark, or whatever it is, your logos, your words, your slogans and catchphrases, you must get it right first up. Once that's in, that's it. There's very, very little opportunity to make any change. You can perhaps reduce your scope, but you can never ever add to it. So if eventually you want to add something, you apply again and you add those separate claims that you'd like to make. And if you want to change the logo, you have to apply from the beginning and put the new logo in. You can use the same goods and services you've perhaps used for another mark, that's fine. But once it's in, it's done and dusted and it cannot be changed. So get it right at the outset. And as I say, if it turns out your business expands and you want to add, then you simply apply again for those things that you want to add.
Great answer, Louise. And I've got another one here that's come through from Anton, which is, what is an average cost for, say, a logo trademark registration?
So we will be able to give you some offers that we have once the webinar is finished, and they will be circulated. The IP Australia costs vary slightly, so it makes no difference if it's words, logos, catchphrases. They are $250 to $330 for each class. And they vary simply because there's pick lists, that's the cheaper way to go. If you want what I call free text and you want to make a description of your own, that's the $330. So there's only really the two costs. One's the simple, cheap, easy. The other one is a little bit more, it gives you more options and a little bit more scope to use it. But they're the IP Australia fees at least.
So you could have multiple classes, of course. So you could have, say, 5 classes. So it'd be 5 times $330 if it was a bespoke one that you're using. So summarising, how can we help, Louise?
So we've covered lots of information today and we'll take more questions as they come through. But our final takeaway point is that you need to be very aware that competitors are always on your heels. You can, of course, go away and search all the registers and jump on the IP Australia website and register marks. However, generally, we recommend that you seek legal advice to avoid complications and to make sure you have a clever strategy in place for distinguishing your mark and ensuring your registration goes through. So for those of you who may be time poor or are unsure of which classes to register in, or you might be aware of some similar marks or competitors that might object, or you just want to get it right the first time, of course we're here to help. We can do as much or as little as you like, from branding guidance, comprehensive searches, applications both for Australian and international trademarks. We provide expert legal advice on the whole process, or perhaps just a response to an examination report, or even all of the above. You might also be considering selling your business or licensing your IP, and we can certainly help you with those agreements if needed. If you're a chamber member, you will receive an offer via email at the end of the day, or so in relation to our IP services, do keep an eye out for that, along with a copy of this recording, if you didn't catch something and want to go back and listen to it again. And of course, NSWBC members can call the advice line anytime if you want more specific questions answered and you'd like us to talk about those.
Okay, so we are at the end of our formal content and our contact details are up on the slide. As Louise mentioned, New South Wales Business Chamber members can of course contact the advice line and the numbers up there, or you can get in touch with us directly through the ip@ablawyers.com.au email address, or have a Google and find us on the Australian Business Lawyers and Advisors website. So
Thank you, Louise and Susie. There's one more question there from Christian. Would you like to answer that one on there as well?
So that's the last one that's come up there, Louise. So I've been told, the question is, I have been told that if you have a trademark on a logo, it will not cover someone from trading in your business name. You need a word or text trademark to protect your business name. Is that correct?
No, that's not entirely correct. A word mark is a much stronger mark than a logo mark. However, the words or text that appear in a trademark, they can often be, if they're a significant element of the mark, they can often provide some protection for you. If your logo is simply pretty pictures, then of course, but if there are words included and those words are a significant element of that logo mark, it's likely that you will have the protection that you're after.
Okay, so I've got another question that's come through here, and it's, I've got an Australian trademark and I have an online business. How do I extend my mark to an overseas audience?
So you can use the World Intellectual Property Organisation. There's those countries. So there's the USA, EU, UK, China. There's a whole lot. There's a great long list of countries that have actually signed up to the Madrid Protocol. And you base your applications on the Australian mark. This is a much, much easier way to go. So if you want to extend to one of those sign-up countries, you put your Australian mark in, and then you base your WIPO application upon that. One of the beauties of that, of course, is the priority date, which means the date that your mark is protected from, so the application date, will be backdated on those WIPO applications. So if you make an application through WIPO and it takes a while to get through, ultimately if you reach registration in that country, it's backdated to when you originally put in your Australian application. So that's actually really handy. There are some non-WIPO countries. One of them, interestingly enough, is Hong Kong. There's also Taiwan and quite a few others. So generally speaking, you should instruct a lawyer who has a trusted local agent to act on your behalf. And remember also, if you're going to extend your mark to China, sometimes it's appropriate to have what's called transliteration. So this is so that the marks will make sense in the other language. So, for example, there was Mr. Muscle, which was the cleaning product. When they went to put their mark into China, the transliteration literally was called Mr. Chicken Meat. So obviously a transliteration was necessary to get that right. So it's not necessary to do that for marks going to China. You can simply use English words or your logo and just apply through WIPO.
That's really good advice and a great example. So there's a few more questions that have come through, and some of them are a little bit specific, so we may take some of those offline, but we'll just have a little look at a question from Paul. Paul says, I have a branded product which I have registered and trademarked. We sell our products online. We have found another online business selling our products and using our images and description wording. They use our brand name by saying on their landing page that the items are by our branded name, and they claim they're only distributing our product. Are they allowed to do that? That's a really, really specific question,
Yeah,
Paul.
They can. It depends on whether or not, if they are representing to the world that they are you, then they can't do that.
So that might come under, for example, a passing off claim if you think that they're trying to pass themselves off as you. But you know, if you haven't given them permission to use your mark, then potentially they're infringing your trademark. It really depends on all the evidence and the circumstances and the defences that may be available to them.
But if you've got a registered trademark and the facts will support the fact that they are infringing your mark, then you've got a strong likelihood of enforcement action because you've got the protection of the Trademarks Act and the provisions within that Act that give you those enforcement abilities. So maybe you could contact us again and we can go through your specific situation because it sounds like it's a little complicated, but it's worthwhile looking into because that's the point of a registered mark.
So I think we've probably got time for one more question. There's one here that says someone else has already registered a trademark for the word of one of our products many years ago. This mark is due to lapse in August this year, and they haven't been operating as a business anymore as far as we can tell. How long after their mark lapses should we wait before applying for the mark? Will they be notified that we have applied even if their mark has lapsed?
Okay, so that's a good question. So once that mark is lapsed and it appears on the IP Australia Trademarks website as lapsed, you can go ahead and apply. They will be notified that their mark, well before their lapsing time, they will be notified that it is due to lapse. So if they don't have any intention of renewing, then by the time it lapsed, it's lapsed. And they will not be notified that you have applied. Once their mark has lapsed, it's lapsed. They won't be notified any longer. It's dead. It's dead to the world. So if you can see that's going to happen, go forward, jump in, go in both feet and apply for the mark that you want. It's yours to take once the mark has lapsed.
And that's why I guess it's really important to make sure you do pay those renewal fees and you don't let your mark lapse because someone can jump in there ahead of you. And similarly, it's not like they get notified that their mark has lapsed, but of course there is that opposition period where your mark will be advertised for a couple of months, and so then they may oppose it based on prior use or some other reason at that stage.
Well, thank you very much, Louise and Susie. Excellent information, and I'm sure all our listeners will agree today. There are a few questions, and I think as both the ladies have said, Louise and Susie, please take these ones offline and contact them direct because some of them are quite specific, and they will get back to you. We thank everyone for participating. We will be in touch later this week with a copy of the slides and the link to the webinar on demand. And also mention was made by Louise Baven that there will be an offer coming out with these slides and with the recording. And I think it's very attractive, so please do not hesitate to contact them direct once you have obtained this information. Just a reminder that if you are unable to attend the live webinar, the New South Wales Business Chamber members can access webinars on demand through their login after registering for the webinar. And local chamber members and non-members who have registered will be emailed a link to the webinar on demand. Thank you both, and thank you everyone for participating today.